I will speak about balance, and married people in this room know how not easy it is to reach. How can media influence a fair trial? A lot. That's easy answer, but should not. Listening to the morning session, I was recollecting some ideas that I wanted to share, completely rebuild anything I wanted to say, but I will try to follow my presentation and maybe more concern on my daily work as a judge. I went through all instances, and even as it was mentioned, I'm a commercial law judge, still as management of the court, as vice president. We have to solve not only criminal cases. So mostly the media cooperation or not cooperation is about criminal cases, as it was mentioned. But still, even commercial law cases have many things which way we have to manage the information given to media or interest of media. I will start maybe a bit generally with definitions. I try to attempt on basic notions that we lawyers, most of us here are lawyers, use automatically presuming what it is, as it has given content. What is fair trial, open trial, public hearing, and media? And I'm sure that any of you would give the different content of it, because with the technology, everything has changed. Maybe with the fair trial, we can say what it is, what it should be. There is the place where we would meet being lawyers, being judges. What is open trial and openness? Where did it start? In all democracy, all the citizens were participating on trial, but openness today, openness through public hearing, leads to the a bit, not a bit, but a lot deformation. The hearing is not only hearing in hearing room. It literally becomes part of daily life, having it in living rooms of anybody that joins through streaming the information from hearing room. I think this really needs to redefine. What was mentioned in this room was redefinition of media. None of you, none of us know what is media. All we can say is maybe what's standard media. And this way, it's not easy to explain all the other notions. So that is something that leads me again to maybe follow the idea you told, friends or enemies. I don't know if frenemies, but not only about media, because that open trial, it's not only media, meaning journalists. The best is professional, but media today, it is anybody being in hearing room, any citizen, anybody that can tweet, that can inform, that puts comments to anything that happens in front of judge. And public tends to become judges themselves. So today, maybe it tends more to come into position of, I don't think open trial is enemy to fair trial, but we are here to stop tendency to become enemy. The aim of open trial was ensure the quality of proceeding, safeguard protection of parties, and also satisfying the need of public to know. That was what Dirk mentioned, and built the case law of ECHR. Where are the maybe boundaries, which way we should follow the case law of ECHR to have really open trial, but still keep the fair trial. The fair trial must protect fundamental rights of litigant. That's why it's considered to be fair. For me, in the commercial law, working with competence, to be fair in sport, everywhere, is the most important thing. The fair trial means keeping rules of procedure to reach also privacy and rights of litigant or defendant with freedom of access to information of public. And all that I'm trying to explain, what is joined by? By the judge. We are the ones that build the process, which way decide to protect both. That's that balance that I want to explain. So, open trial, really, it monitors against arbitrary decision makings. That's something that was maybe historically led to quite short messages. Even I had this experience before I came to Supreme Court. One of the main messages to the public was judicial decisions should not be commented, they should be followed. We have to fulfill them, not to comment them. No, we know that it's not like that. We need to interpret, even a decision interprets law. We need to interpret also decisions. That's what we do with ECHR decisions and any other. Open trial, really, it used to be a way to elicit further evidence, of course. But today it mostly or slightly gets to the feet of public need of sensation. That's what it really should not serve for. So how to strike the balance? Laws of procedure, for me, or for any lawyer, it's important to follow rules. So laws of procedure mitigate the balance between those two ideals, open and fair trial. What do we use? We can isolate witnesses. We can't isolate those that we do not know which one will come to the hearing room. That's the problem through the streaming, through the getting information from hearing room. We or media influence future witnesses. They influence also victims that are victims and are not going to join trial, for example. Using reporting restrictions, well, it's toothless. Even I apply a gag order or some restriction, with the leaked information, the damage is done. It's irreparable. So I was thinking maybe, and of course I don't mean it, about isolating of judges. Sometimes we are said that we are living in kind of bubble, so maybe to make some extra bubbles, living in special areas without any information, not to be influenced, no? Especially married people would not agree. So that would not work, but why I mentioned isolating of judges? Because this is most important. What we believe in, impartial, unbiased, independent judge. So if we work on it, then the whole process will be trusted. Well, legitimate judge is prerequisite of fair trial. When we believe the judge is somebody that cannot be hit or some way harmed by media work, then this is the judge that we want to have the case decided. Media publishing information concerning the content of testimony can harm, of course, witnesses, maybe any other party. But bringing harm to judge, that makes the things much more complicated. Parties to the case or defendants, speaking in criminal law language, they must be perceived that such a judge decides their case. Judge must keep cool head. Any decision concerning bias of judge says it. If the judge cannot follow efforts to compromise him or her, if he cannot bear this, should disqualify him from the case or should not be a judge. The pressure on us through this kind of public, maybe imagination of which way the judge should work is really very rigid. They we have to feel unbiased, but public must perceive us as unbiased. Why I mentioned ranking of judges? I wanted to maybe lead the attention to something that happens, I don't know if every country, but especially in our country, sometimes ranking of judges is like hits charts, who is the best judge, makes really a bad job to judiciary, because the information from ranking judges leads to the media to compromising. If we can see that the judge has this type of evaluation, how he can decide correctly the case. Moreover, what is one of the most important points is methodology, which way these rankings are done and which way they can cover judges working in teams, in panels. So who is the most touchable judge? The first instance judge, having the case on the table, being in the hearing room, and being, I would say, the one that has that face in media mostly, or I don't know how it works in other countries. What we can do in our country, we can decide which way it can or cannot be broadcasted. If there can be records, we cannot ban recording in the room. We can ban taking our faces, but still the first instant judge is somebody that is visible. As for those rankings, they are those that are subject of interest of public and media, and if their qualities are called into question by pointing to these rankings with really significant weakness of methodology of such rankings that may affect any trial they are working on or in which media is interested. This leads me to expectations of stakeholders. I don't want to conclude my presentation to conclusions. I really don't aim to give you kind of wisdom, because I have none. I have expectations too. I can give you kind of observations. What is that I would like to stress, which way I could see expectations of participants of fair trial, of open trial, and it differs. What are the expectations of defendant? Of course, the just decision, but they want to have protected privacy, protection of fairness, to have a well-reasoned decision. and they believe in unbiased judge. What is expectation of public? Of course, they want to monitor quality of process, and that works. The truth is that having the media in the room, any judge is like maybe more aware, more woke, actually we work sane mostly, monitoring of fairness, and satisfaction of curiosity. So this balance between monitoring of quality of process, what it is more, because that was the aim in the beginning. The public monitors quality of decision making. Now it is feeding of hunger for sensation, mostly. That's why I really respect and highly appreciate professional journalists, because that's what they bring to information, analysis, comments, and that's lost now with the very quick and really with the rapidness of information, with tweeting directly, with streaming the process as it goes. In past time, there was time. The process went, then they analyzed it, and then they published it. Now there is quite short time to do it this way. What's expectation of media? Access to everything, including files. Sometimes they get the information from file, even the information that's not done to judge, that happens. So it really brings danger to the fairness of the trial. So we really should find kind of harmony. It was told here using spokespersons, making information easier, somehow digestible to the public. Being lawyers, imagine who are judges here, you always miss in the given information details, because devil is in details. Our reasoning is always done by very precisely put words, and now when media tries to get very short and easy information, not every judge has this skill, this ability. That leads me to final remarks. So how to strike the balance between open trial and fairness? Which way streaming? Dorota, you mentioned it, and that's what I get to. There is role of judge, role of administration. I would start with the role of judges, because that's the one that decides. He can exclude complete public, they can limit broadcasting. This is what the judge does, and if media does not like it, they try to bring the judge, or they try maybe to disqualify judge, making him too restrictive. So that finding balance is not easy. Of course, I mention following ethical rules, because this is another big topic that we have to talk about, because when the judge is perceived unbiased and really highly qualified, he or she has to follow also ethical rules and to have personal skills. It goes with education. Before I go to the role of administration of court and with some of my recommendations, I mentioned the case that happened in Slovakia. As I told, all of you know about Kuciak murder. Murder of journalist, really stressful, shocking. It's 5 years ago. For me, it's like it happened yesterday. It really was earthquake in the Slovak judiciary, in the Slovak society. And you know what calmed down emotions? When on the appellate court level, after their decision, quashing down the first instance decision, the head of panel went out, experienced, older judge, speaking slowly in easy words, and judiciary just, everybody was quiet, they let him speak, he explained it, and all the shaking and everybody, it was almost lynch. of defendants, no presumption of innocence. But with his words, it really helped. And now everybody waits for the other development, which way it will. But not every judge has this ability. Imagine there would be younger judge, a bit shaking, looking for words because he just closed hearing room full of emotions too. We are also people. So having emotions and not showing them is not easy. So role of judge is extremely important. Not every judge has these skills. That's why spokespersons are so important. So what would I recommend? Regulation of broadcasting, having neutral broadcasting. What I like, that's what Luxembourg courts have. They broadcast. Should I finish? I should. I follow it. So regulation of broadcasting, neutral, no details, no faces, nothing like movie. Regulations through technology, so digital commitment reminder, anything that technology can be useful, and training of judges and high level of communication with media. And my last remark, I like philosopher Jering, and his essay that I know everybody knows is Struggle for Law. We should perceive the trial as struggle for law, not fight against somebody. So with respect to media, to judges, thank you so much. Thanks, ERA, for invitation, and I hope we will have nice discussion. Thank you for your attention.